walking into the waiting room. So my name is Clark Freshman. I'm a professor of law here at University of California College of Law, San Francisco, formerly known as Hastings College of Law. And this is part of our speaker series. And Professor Gilles was just meeting with my students in our advanced colloquium class, giving the best presentation I've ever seen on statistics and the practicalities of forced arbitration. And this is a sensational project that she's working on now, and really has a lot of practical significance for what people may be able to do in terms of legislation and litigation, and also just wonderfully written description of how arbitration would seem to have been just growing like some kind of a monster taking over, is maybe retrenching a little bit and may unravel, as she put it, maybe not all at once, but in some way, as she's predicting. So thank you very much for joining us here. Certainly it's great to have someone from Cardozo School of Law who's worked so conscientiously and carefully on forced arbitration for so long, and not just in terms of scholarship, but also really working with Congress, and even, as you mentioned in our student session, with Senator Cruz, and talking to Senator Cruz about his sources of information about why class actions might be bad. So thank you very much. The usual expectations apply, and you can follow them as you like. Different speakers do to different degrees. So about like 20 minutes or so to introduce the ideas and give people an opportunity to make questions and comments. And I feel very lucky that we have two of the leading scholars, at least, on arbitration here, Jean Sternlight from UNLV, and my colleague here, Argaki, the director of our Center for Negotiation and Dispute Resolution. So Myriam, take it away. Thank you very much again for being with us.
Thank you so much, Clark, for having me. It was great speaking with the students, and I'm excited to talk to you all about this paper. Clark, do you mind making me a co-host once again? I am going to share some slides. And it's great to have Jean and Hiro here as well. People whose work I admire and from whom I've learned so much. So thank you both for being here. It's been a pretty bleak decade for people like me who believe in the power of aggregate litigation to sort of level the playing field and provide justice for small value claims. And this is largely due to the rise of class action banning forced arbitration clauses, which everybody in the room is bound to. These are, as you all know, provisions that force weaker counterparties to agree to surrender their right to go to court, and instead they're shunted off into a private legal regime with no right to a jury, no written record, very limited rights of discovery, and most importantly for this project, no right to aggregate litigation. So the Supreme Court has, in a series of cases, upheld these provisions as against all manner of legal challenges, basically giving carte blanche to companies that impose these provisions on their consumers, workers, and others. Here are some lowlights. These are all decisions that you all recognize if you're in this field. The result is exactly what one would expect, right? Fewer class actions. And there's quite a bit of empirical data to support this commonsensical claim. But here are just a couple of data points to get us all on the same page. So a Times investigation found, for example, between 2010 and 2014, only 505 consumers went to arbitration against Verizon's with claims less than 2,500 or less. And that's even though Verizon has more than 125 subscribers. Time Warner Cable, similar stats. And here's a slightly more updated recent study. Despite having millions of consumers, companies like Amazon, Walmart, and AT&T rarely face legal claims. And it's not just consumers. Economists have told us that over the past number of years, employees, workers are more and more are increasingly bound to arbitration clauses. By the end of this year, labor economists at the EPI, the Economic Policy Institute, predict that over 80% of non-unionized workforce will be subject to arbitration That's 85 million workers. So that's all just background to tell you that it's been a very depressing decade for me. Uh, you know, I feel like I've been the sort of dark force of just predicting and arguing that this is just getting worse and worse and worse as opposed to better. But this article, is hugely optimistic for me. Because I suggest, as Clark introduced the article, that the tide may be turning. And I point to a bunch of changes, both legislatively, judicially, and then finally some market-based approaches that I think might or should give access to justice advocates some reasons to start feeling hopeful again. So I'll start with the legislative arena. Congress in 2021 passed the bipartisan Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, amending the FAA for the first time in over a century to prohibit claims of sexual misconduct to be forced into arbitration. I testified in the House Judiciary Committee in 2019 in support of this bill. I did a bunch of markup sessions with legislative staffers in the run-up to passage. Let me just pause here and say, to be honest and frank, even though this is being recorded, initially, I was pretty concerned about this bill. First, I was worried, as were many, many others, sort of similarly situated to me, that it was far too narrow. It applies only to a certain slice of claims. Why sexual misconduct? Why not all worker claims? And relatedly, and maybe more realistically, I worry that passing this law would take the wind out of our sails, that it would make it would mean that we would never pass the broader Fair Act, which would prohibit forced arbitration in all contracts. Legislators would basically feel like they'd solved the problem and they could walk away. And look, I still worry, right? I ended up supporting the bill, but I still worry. But what is it they say? Politics is the art of the possible. And it felt like this was possible at this moment. It was what we could do. And I was ultimately convinced that it was at least a step in the right direction. We are seeing nearly identical bills that would prohibit claims of race and age discrimination from being forced into arbitration. So that's a sign, right? Cory Booker has a bill, and I can't remember I think Gillibrand has the age bill, but there are a bunch of different bills circulating that look a lot like this. So maybe that's a good sign. And then, just early days yet, but we know that FSASHA, as it's being called, so far is doing pretty well in the district courts. It's being interpreted very broadly. So, for instance, district judges are finding that litigants who allege various kinds of discrimination, say race and sexual discrimination, that those claims must all be brought to court, that you can't split those claims up and have one set go to arbitration, the other set go to court. That's pretty good, right? Because we're seeing then more claims than would otherwise be allowed into court getting into court. So I think this is a space to watch. We'll see what happens next or what happens later in Congress. But let's be honest, we've all stopped looking to Congress to do much for us as a country, right? All of our focus seems to be on what the Supreme Court's going to do. Not sure what all that stuff is over there. Let me talk a little bit about the court. I'm going to focus on three decisions. Since 2010, SCOTUS has decided, by my count, 22 cases interpreting the FAA and has upheld arbitration in nearly all of them, except for, can you all still see my screen, or did that go away?
Hey, Myriam, I was fixing the little writing that was getting on the corner of it. So if you reshare now, you should be all right.
I see. Great. Thanks. I don't know what that was. Oh, I'm disabled from sharing.
Oh, okay. That means we have to remake you host. Oh, that's weird. Karen, can you make her co-host, or she is, okay, I think that's why we had it as all participants, but that means other people can do a little drawing on your slides, which is what I was trying to avoid.
Oh, yeah, that's okay. People, I mean, if you want to draw on my slides, I'm fine with that.
Okay. Thanks.
All right.
Sorry about
so
that.
We're back. Okay, great. So just focusing on the Supreme Court, I'm going to start with FAA Section 1, which directs courts to enforce So the FAA tells courts you got to enforce most arbitration clauses, but right up front, Section 1 of the statute excludes from its coverage employment contracts of, quote, seamen, I think I have this on the slide actually. Yeah, here it is. Seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. So in 2001, in a case called Circuit City versus Adams, SCOTUS was called upon to interpret this language, and in particular, this any other class of workers language. And I would argue, instead of giving the statute its plain meaning, all workers, a 5-4 court in Circuit City applied the canon of ejusdem generis, which is a canon of statutory construction that teaches that when general words follow specific words in an enumerated list, the general word should be construed to mean the only things similar to those in the enumerated list. So here, any other class of workers, the court tells us, should be interpreted to mean something pretty close to seamen and railroad employees, right? Not all workers, but pretty narrowly those kinds of workers. And applying that canon, the court held that only interstate transportation workers are going to be eligible for FAA 1's exemption. This is despite a lot of legislative history with Justice Stevens' details and his, I think, really brilliant dissent, all ignored, and ejusdem is what's used here. So all that's just background to say that in recent years, one thing has become quite clear. Figuring out what constitutes a transportation worker is pretty darn difficult. The question has bedeviled courts, thrusting them into the minutia of figuring out exactly what workers do, where they do it, how long they do it, where they travel to do it, what percentage of their time is spent doing it. And finally, in 2022, here we go. In 2022, in a case called Southwest versus Saxon, the justices got into the act and they unanimously held that workers who load cargo directly on and off a plane that's headed out of state are transportation workers for purposes of FAA 1's exemption. Now, I'm sure you're all sitting there going, all right, so what's the big deal? This doesn't seem like that much. Is this a big nothing burger? I realize it doesn't sound like much, but Saxon, first of all, sets off a flurry of worker cases pouring into the federal courts seeking FAA 1 exemption. By last count, there are over 4,300 FAA Section 1 cases filed since Saxon. So that's, it's not a nothing burger if you got 4,300 cases suddenly in the courts seeking this exemption. SCOTUS itself just heard argument just maybe 3 weeks ago in a LePage versus Bissonnette, yet another case involving this same question. There it was a bakery delivery truck driver who's arguing that he sometimes crosses lines to deliver bread to restaurants in the morning. So we'll see what happens there. Jen Bennett argued that case. She also argued Southwest versus Saxon. And though I wasn't there, I listened to it, and I think she's going to win that case. All of this to say that the increasing incoherence of Circuit City's interpretation of FAA 1 could mean that we're just stuck here, right? Case after case after case, trying to figure out and work out on a worker by worker, case by case basis who gets FAA Section 1 interpretation exemption, or it could mean that Circuit City is ripe for re-examination, right? That maybe we have a frontal attack on Circuit City. So hold that thought for just a moment, because I need to tell you about one more case before I can tell you about this planned frontal attack. And that's the case of Morgan v. Sundance. This is, again, another 2022 decision out of the Supreme Court. And once again, you're probably sitting there thinking this is not that interesting, because the question presented looks pretty, small bore, to say the least. Here's the fact pattern. Imagine an arbitration-bound plaintiff, somebody with an arbitration clause in their contract, files a lawsuit in court, and the defendant, instead of immediately moving to compel arbitration, instead moves to dismiss, maybe even proceeds with a little bit of discovery. And then, and only when it starts to think, I'm not sure we're doing so well in litigation, maybe they lose a dispositive motion, or just for any other reason, the judicial avenue starts to lose its luster, The defendant pivots and then moves to compel arbitration. Can the defendant do this, or has it waived its right to pursue arbitration, having engaged in some litigation? Now, I want you to think about all the other instances in which courts face this question about waiver. For example, if an out-of-state defendant appears in a forum to defend itself on the merits, that defendant will have been deemed to have waived its right to challenge that court's personal jurisdiction over it. Courts have no problem finding waiver once you show up and you litigate. Similarly, if a litigant fails to timely file a jury demand, they will be deemed to have waived their right to a jury trial. So we find waiver in all sorts of instances, and we're pretty aggressive about waiver. But in the arbitration context, courts were very reluctant to find waiver. Indeed, 9 of the courts of appeal, by the time Morgan got to the SCOTUS, had imposed a heightened burden on plaintiff to show that they would suffer prejudice if the defendant were allowed to switch to arbitration midway through the proceedings. These courts all understood that, look, the Supreme Court tells us that there's a healthy regard for arbitration. There's a national policy favoring arbitration. So we're going to do everything we can to uphold arbitration, even where it means making the plaintiff have a heightened standard to show waiver. In Morgan, the court unanimously reverses, right? So this is the question presented. Must plaintiff prove they would suffer prejudice, or should arbitration be treated like any other waiver? So this is Justice Kagan writing this decision. She directs the lower federal courts to abandon this special rule. But most critically, I think the most important part of this decision is the pronouncement that the federal policy favoring arbitration it prohibits courts from inventing special arbitration preferring procedural rules. Instead, it requires that they place arbitration agreements upon the same footing as other contracts. This, I submit to you, is significant. It's not the first time we've heard the court say this, but I think this is pretty significant because it means that all judge-made arbitration-specific rules created in the service of the supposed national policy favoring arbitration are now up for grabs. And back to Circuit City for just a moment. So again, this is FAA Section 1, and this is the any other class of workers language that was analyzed by the court in Circuit City. My claim is that only arbitration favoritism can explain the Circuit City Court's decision to apply ad justem generis when a plain meaning construction was clearly available here. Right? Outside of the FAA bubble, just to give you a sense, courts routinely hold that ad justem is only available where the statutory text cannot be given its plain meaning. Here, there is a plain meaning, right? And so I think if we have a chance to frontally challenge Circuit City, we should take it because Morgan's logic undermines the court's arbitration-specific use of ad justem in this context. Given again the plain meaning. And I think given that we have justices like Gorsuch and Kavanaugh and Barrett, who all of whom have written that these statutory canons of construction should not be used when a plain meaning is available, I think we have the right court at the right moment to maybe take a real stab at Circuit City. I wouldn't blame you if you thought that this goes completely against other aspects of this court, right? Again, the sort of pro-business, anti-litigation court. So maybe those are competing currents here. But be that as it may, I think a challenge to Circuit City is very much in line with the pro-plain meaning court. And so I think that this is worth thinking about, and it's something I'm writing about right now. So we're happy to talk about it more in Q&A. And then I've got a final case I want to talk to you about. It's a case called Viking River versus Moriana. This is a challenge to California's Private Attorney General Act, PAGA. This is a state statute that looks a whole lot like the Federal False Claims Act. It deputizes aggrieved employees, allows them to bring representative actions on behalf of California's Labor Department for violations of the Labor Code. For those of you who are in California, you know that PAGA is constantly under attack and is currently on the ballot there's a massive referendum effort being launched by the Chamber of Commerce. So we'll see if PAGA survives. But before all of that, there was this litigation. The question before the court, can a PAGA relator, this is an individual employee who's bound to arbitrate an employment dispute, nonetheless serve as a representative for the PAGA claim in court, seeking redress on behalf of the state for the state violations of the state labor code? I'll be honest, I remember exactly where I was when I heard that cert had been granted in this case, and I was terrified. I just thought, that's it, PAGA's gone, right? The court's going to find that the FAA preempts PAGA, and that'll be done. So I was pretty surprised by the outcome here, because that's not what happens. Instead, in an 8-1 decision written by Justice Alito, the court does not strike down PAGA as preempted, but instead tells us a PAGA plaintiff has to go arbitrate their individual claims. But then the question of whether that PAGA plaintiff can still represent the state, that's really not for us, the Supreme Court, to decide. That's for the California courts, the California Supreme Court, to decide as a matter of state standing rules. It's not really something that we can tell you. And about a month after Myriam was decided, the California Supreme Court did decide in a case called ADR versus Uber that an arbitration-bound PAGA plaintiff does retain standing to bring a PAGA action. No Article 3 standing problem, because California courts have a different view of standing than federal courts. Now, once again, this may not sound like much, but the reason this case was really important to me, and I wrote an amicus brief in this case, is so that at the time Viking River was granted cert, I was working with advocates trying to get PAGA-like legislation in other states. This is what I was about to show you. States like New York, Vermont, Washington, and Oregon. So the cert grant was very scary, but I'll tell you, one of the big obstacles to getting state legislators to think about enacting PAGA legislation was their fear of preemption litigation. They were so worried that if we pass this statute, we're just going to have to defend it in court, maybe all the way up to the Supreme Court. But Viking River sweeps away those concerns. And now these states and a handful of others have active PAGA bills on their legislative agendas for this year. I'm testifying on behalf of New York's Empire Bill in about a month, and I have high hopes that it will pass. So, I think Viking River might seem like not a big deal, but it could actually have pretty significant impact on a state-by-state basis. So I think the takeaway from our jaunt through these Supreme Court cases is that some aspects of arbitration jurisprudence seem suddenly up for grabs. In particular, FAA1, I think, seems ripe for revisiting. And if that fails, a state-by-state approach like what we're seeing with California's PAGA statute might be a viable option. So I'll end here with just a little bit on the private market-based response to class action banning arbitration clause. This is the recent phenomenon of mass arbitration. It's a fascinating area. It's really evolving very quickly. Too much to say about it than I'll take the time to say here, but I'm happy to talk about it in Q&A. So briefly, you recall where we began. Individual litigants will rarely file arbitrations on their own to resolve small value claims, because without the ability to aggregate, it's hard to see how contingency fees on individual claims are going to be worth a lawyer's time. But, that was our thinking back in 2010, 2005, 2010. Fast forward to 2019, and plaintiffs' lawyers hit upon this strategy. Let's file thousands of factually identical individual arbitration demands in one fell swoop against companies like Uber, Intuit, DoorDash, all the companies on the left here. And the idea is when they are facing the massive filing fees that they have agreed to pay to make their arbitration clauses look good and look consumer friendly, they're just going to buckle under the pressure and decide to just settle with us instead. So I've given you a list. This is not a complete list, but this is a list of some of the biggest mass arbs that we've seen so far. Note a couple of things. The mass arb strategy only works where a defendant company has promised to pay the bulk of the upfront costs and the arbitrator's hourly fees. in their contract, something, again, many companies did to try to make their provisions seem reasonable and enforceable. I do want to spend a moment longer just to show you how this leverage works. So let's take Uber, for example. In 2018, 12,300 drivers filed individual arbitrations with the American Arbitration Association alleging violations of California's minimum wage statute. So this is the AAA fee schedule for employment claims. As you can see, the driver's claims individually are capped at $300. That's about the cost of filing suit in a California state court. So that's the maximum that any Uber driver had to pay. The remaining amount, $26.50 per arbitration, is all payable by Uber. So plaintiffs' counsel, they do have to put some money in, right? They end up having to pay $3.7 million. That's $300 times the 12,300 drivers. But Uber has to pay $29 million, right? That's the $26.50 times the 12,300 individual drivers. That fee differential is $25.3 million. So that's where all the leverage comes from. Just wanted to show you so that's the fee differential. Keep in mind, this is just the filing fee, because Uber's ARB clause also promises that the company will pay all arbitrators' fees, and AAA arbitrators can charge anywhere from $300 to, I don't know, $1,000 or more per hour. So the total cost of arbitrating 12,300 claims, if it could even be done, would be upwards of many more millions of dollars. So you can see how mass arbitration creates some pretty serious leverage. And though it does require some investment by plaintiffs' lawyers, litigation financiers are very engaged in this space. So this is not going to be an issue. So I don't know, call this what you'd like, poetic justice, death by 1,000 cuts, extortion, or, the way I see it, just to, tell you my view, this is payment for maintaining a class action banning arbitration clause for over a decade, right? This is what you get. This financial exposure is forcing companies, though, to find ways out, right? So I'll end here. And the paper goes through some of the anti-mass arb efforts and rules that we're seeing, because what these companies are trying to do is they need to find ways to deter mass arbitration while maintaining their immunity from aggregate litigation. That's a hard balance to achieve. So I described some of the rule and provider changes the companies are making, many of which are being challenged as we speak. Now, where mass arb ends up, I think, is anyone's guess. But plaintiffs' lawyers are no longer running from arbitration. Instead, they're engaging in these fora. And I posit that these companies never intended to actually have to arbitrate these claims. So this, too, just like the Supreme Court's recent jurisprudence and FSASHA, these are reasons to sort of become a little bit more hopeful that possibly this edifice, this arbitral edifice, is starting to show some wear and tear. So I'll leave it there. I had one last slide. It's a slightly complicated concept, but one thing that companies may do, and I'm also writing about this too, because I'm starting to see it. One thing they might do is just try to hold on to the class action waiver without the ARB clause. So what about a standalone class action waiver? Now, I think if you'd asked me in 2005, is a standalone class action waiver in a contract, thou shalt not bring a class action against me, is that enforceable? I would have thought, no way, right? No way that's enforceable. I don't know what the law will say today. We haven't seen that many standalone class action waivers, of course, because they're always embedded within arbitration clauses. But my thesis is that what this will require, if it indeed happens, is for us to go back to the map right before Concepcion. What were these states saying about the public policy favoring class actions, the importance of aggregate litigation to rights bringing, the sort of the arguments against exculpatory clauses? I think we go way back to kind of unconscionability, common law unconscionability doctrine as it existed before Concepcion. Because in general, we've got to acknowledge once you take the ARB clause, once you take the class action waiver out of the ARB clause, the FAA is no longer serving any protective function. So we're just going to have to look at these provisions as they stand and ask whether they're enforceable. So I think I've gone over my time. I apologize for that. But I look forward to hearing any questions or comments.
Well, thank you very much, Myriam. I see we have two interesting comments in the chat. I don't know if either Shirish or Eitan would like to share their comments, or if you want to respond to what they have there, Myriam.
Yeah, so Shirish talks about the AAA.
Hi there.
Hi. Do
Hi,
you
sorry.
want to talk about it a bit?
Yeah, so I actually serve as an arbitrator on mass arbs plus mediate them, and the landscape has significantly shifted since January when AAA enacted their new rules, focusing more on process arbitration or process arbitrators, and changing their fee schedules. So the dynamic where claimants had 5,000 potential claims and said it behooves you to settle now, that's changed. Settlements are still happening, but the values of those settlements are going down substantially.
Yeah. So can you tell me more? Because you sound like you have inside information, and it's actually hard to know what's going on from the outside because, of course, all of this is very private. My understanding about process arbitrators, because you mentioned process arbitrators, the parties have to both agree on process arbitrators.
Not anymore.
Not anymore. I see.
Yeah, so AAA changed the rules in January.
Yeah, I've read the rules. I didn't see that was a change.
Yeah, so AAA can appoint the process arbitrator, and I believe it's the respondents are all asking for the process arbitrator to be appointed. They can batch cases, they can stay matters, or I should say cases, arbitrations, stay matters. I've not served as a process arbitrator, so I can't speak.
What would be the grounds for staying an arbitration under these new rules?
So it would be if there are 5,000 of these, let's choose 5 of these, and the rest will stay, and then we'll work out a settlement based on the 5.
Yeah.
See how it goes.
Yeah. So, I mean, if you come at it from my viewpoint, this is a bummer. This is the AAA. This is the race to the bottom. This is the AAA competing with a bunch of other, not so great arbitral companies, companies like New Era, and these sort of newfangled companies. I think 3 cheers for Jams for sort of sticking to their principles, because I don't think the idea should be to make it easier for companies to get out from under these ARB clauses. I think it's crazy that you should be able to stay and not have to pay the filing fee for the ARB, for the individual ARBs. If plaintiffs are going to bring these ARBs, you should be willing to pay these filing fees and move forward with them. So I'm bummed that the AAA did this. To me, this is a sign of, more corporatist takeover.
Hold off on the 3 cheers just right now.
Because are they going to change their rules as well?
So I am at Jams. I do not have any inside baseball knowledge about whether we're going to change our rules. But I wouldn't be shocked if we did.
Well, it is a business after all, right?
Yeah, and AAA, I'm not sure if you're aware of the board of AAA is substantially corporate America.
Yeah, I know.
Yeah. So I wasn't surprised at that.
Yeah. Yeah. Thank you for that. That's really, really helpful. It's really, really helpful. I have a colleague, Luke Norris, who has a paper where it's not Luke Norris, it's Richard Frankel has a paper coming out in Vanderbilt Law Review about mass arbitration. And his thesis is essentially that arbitration is just not made for mass claims. That if Justice Scalia got anything right in Concepcion, it was that this forum is not the right forum for mass claiming. And so when we start to see some of these issues come up in the effort to try to use it for mass claiming, whether it's aggregate or individual, we're going to start to see problems. And I sort of buy that thesis that this is a problem with the forum, not so much with the rules.
Sorry, what's the problem with the forum?
That it's not made for mass claiming. It's not well set up for, situated for just having single file claims that are all identical. Query whether any forum is good at that, right? Because that's the reason for aggregation. That's the reason we have a Rule 23, is because collectivization is actually more efficient and fairer for all parties. But so this whole idea of kind of single file claiming was always a problem. It's just now we're seeing it because plaintiffs are actually trying to make defendants live by their contractual provisions.
Yeah, and there are efforts being taken in the arbitration space to make it more efficient, even though they're not consolidated. Like, for example, if you're going to take the same corporate representative's deposition, you just take it once and use it in all 2,000 claims.
Yeah.
You don't have to do it 2,000 times and ask the exact same questions over and over again.
Right. Yeah. I mean, but maybe to make it truly efficient, there would be res judicata effect. There'd be written decisions where we could, read what one arbitrator found. And, so, we can agree to disagree about the value of arbitration in these contexts, but it's not going to work well long term for this sort of issue. If you've got 12,300 Uber drivers who feel that they've not been paid correctly under California's minimum wage statute, that's just a lot of individual claiming. I mean, it's hard to imagine that there's any system, no matter what little rule changes you make, that's going to be more efficient than just aggregating those claims.
Fair enough.
There's a note here by Eitan Adler. Is Eitan here?
Yeah. Hi.
Hi.
Hi. I had a question. You talked about overturning, or you mentioned that overturning Circuit City. I was curious whether you saw any chance of overturning the original sins of Keating or Gilmer that completely also misinterpreted the FAA and made it to give arbiters the ability to do statutory interpretation. Sorry. Statutory claims or other kind of.
From your lips, man. I mean, I'd love to take a run at Gilmer. It's just harder. There's not as much. I mean, we should talk about this offline. I don't see a clear pathway the way I do with Circuit City, and it's just a perfect storm with Circuit City because the court got like 30 or 40 cert petitions this year, for FAA1 exclusion. We're seeing a lot of interest by workers in trying to get that exclusion. So there's just a ton of activity, and it all rests on this really wonky reading of any other workers in FAA Section 1. Whereas, Gilmer, I mean, look, I think all those cases are badly decided, wrongly decided. Gilmer is just going to be a harder case to go at, right? We're not going to get this court to just disavow, the FAA jurisprudence. My only chink in the armor is that I think that we might be able to get 3 justices that would otherwise never stand on this side. This is Barrett, Kavanaugh, and Gorsuch. We might get them to just feel like, because they've written about this, that the canon of construction used in Circuit City is just not applicable to FAA1. Right. So it's a very narrow entry path. The broader war, I feel like we might even have a better chance of getting the FAIR Act through than getting the Supreme Court to disavow Gilmer. But if you have ideas, I'm very open hearing them.
Yeah, that makes sense. I was just curious.
Yeah.
Myriam, I think we have a few other questions. You're welcome to call on people, or Hero, you can go with the next question.
Okay, great. Thank you, Myriam, for this excellent presentation and very thought-provoking. I admire your ambition to try and overturn some of these Supreme Court precedents. And I used to be of that school of thought, but now I'm actually wondering about just scrapping the FAA itself. So I've just been looking at the FAA in comparative perspective. So I looked at 197 countries around the world in their arbitration statutes. And it turns out that the FAA is the third oldest arbitration statute in existence today. Eswatini, formerly known as Swaziland, and Chile are the only two countries that have older arbitration laws.
Mm-hmm.
And Chile at least has updated its International Arbitration Act. The centenary of the FAA is coming up in 2025, and there are lots of calls for reform.
Mm-hmm.
Do you think that some kind of an overhaul, not just a tinkering with this or that section of the FAA, but a complete, blank slate, new arbitration act, maybe modeled on the model law from UNCITRAL or something of that nature, but in particular one that makes it clear that there is no longer going to be a doctrine of FAA preemption? Would that go quite far in terms of addressing these issues if you essentially allow states to regulate in this area?
Yeah, that's great. And I would love to see this project. This sounds fascinating. I'm no comparativist, but it sounds like it's worth doing because, of course, when you say arbitration to most people, they think about international business transactions, right? And in those settings, arbitration might make a tremendous amount of sense. So we're really talking about a statute that's trying to do a lot of work domestically. Hiro, I have not thought enough about the bigger picture of what an overhaul to the FAA would look like. But I do think, two provisions come to mind. You've already stated one. I think there should be no preemption. I think states should be free to regulate in this space. And second, I think that these provisions should not be imposed in standard form agreements on a pre-dispute basis. I think that those two things are deeply make current practice feel very unfair. I will say, and I've seen some work on this, but I don't know it well. Every state also has an arbitration act, and has some interpretive law, jurisprudence interpreting their own arbitration act. So one question I have, I guess I'd put it back to you, Hiro. In this moment when we find ourselves so divided, right? The red and blue states seem so different in so many ways. Can we trust states to regulate arbitration in the ways you're thinking of, in ways that might be liberal and pro-citizen, pro-consumer, pro-worker, pro-small business? I don't know. And of course, I'd certainly worry about the patchwork that would result. But, I think I love the idea of rethinking the Federal Arbitration Act. I'd love to be in the room when those conversations are happening. I hope you are, because I think it's high time to think about what it is we're doing with this statute, and all the claims that slip through the legal cracks because of it. So thank you for that. I-10 asks if New York's law is older than the FAA. It is. In fact, the FAA was modeled against the New York Act. I think the next question I see is Karina. Hi again.
Hi. So last week in our Professor Freshman's class, when we discussed your paper, we were focusing in a little bit on the discussion about the hashtag #MeToo, the section of the paper discussing that. And we were wondering about the impact you think maybe about organizing public opinion, and sort of what are the most effective strategies for advocacy and for groups, and to employ, like, leveraging public opinion over arbitration clauses into actual policy change. Because I think so many of us just sign on to this and don't even know that we're doing it.
Yeah.
And I think that could be really powerful. And we were wondering about your thoughts in that.
I have a lot of thoughts. They're less optimistic than the tone of the paper, only because I've been doing this for a long time. And what I've found is that arbitration is just not a sexy enough topic to really get people to stick with you. I feel like I've done a lot of trying to canvass and talk to especially workers about arbitration. And maybe just because it takes a little longer to explain, maybe because, we're humans. And so at the beginning of any relationship, whether it's a marriage or your cell phone contract, we are very optimistic, right? And we're not thinking about the end game and how the relationship's going to go sour and need some dispute resolution around it. So it's very hard to get people to focus on arbitration. I think that, we've seen some groups be able to do this well. So, for example, with Google and Facebook and a bunch of other tech companies, workers became very radicalized around forced arbitration and staged a series of walkouts until those companies agreed to abandon forced arbitration provisions in employment contracts. Not just with themselves, but also they asked their vendors and suppliers not to have ARB clauses with their employees. So that was pretty powerful. There's a group of young women when they were at Harvard Law School. This goes back about 6 or 7 years. They all realized when they became summer associates at big firms that the stuff they were signing, those orientation documents, contained forced ARB clauses, and they staged a huge blackout of any firm that would impose these provisions on summer associates. In other words, those firms were not allowed to do on-campus interviewing at Harvard Law School. I mean, you have to be that fancy, I guess, to get people to pay attention. But people paid attention, and those law firms dropped their ARB clauses to summer associates. And next thing you know, they had to drop them as against all associates and all staff, right? Because you can't really draw the line at summer associates. So we've seen public opinion have some impact in some spaces, but boy, the places and the manner it's had impact, I worry, because we don't see low income workers, in these conversations. We don't see Black and brown people who are much more often subject to forced arbitration as compared to other workers. So, I'm all for getting the public riled up on this issue. I've often wondered why we can't get the public riled up on this issue. But I'd really hope that however that happens, that we're able to do it in a way that that doesn't just ensure that pockets of consumers or pockets of employees are given a pass on arbitration, that it's for everybody, which is why it really has to be the stuff of legislation, right? Clark, I'm not seeing anybody else, but you tell me if you're seeing someone. No.
Sorry, I'm not seeing anyone else, but I did notice there were 2 people, including myself, and Jean, who had comments about the question of state law, and I wondered what thoughts you had about that. My comment was that I think that even if state laws, some of the states were more
they could just
pro-consumer, then there would be a race to the bottom to some extent. And I'd have to check with my choice of law and civil procedure colleagues a little bit better about this. In the extreme, you could think that people would just designate the most sympathetic states. So if I recall correctly, Missouri's law of unconscionability, the last time I taught arbitration law, was that something is only unconscionable if no decent person would ask for it, this clause, and no reasonable person would agree to it. So it's a pretty sympathetic standard for those drafting the clauses. What I don't know, what might provide something of a check is it might be that companies would only be able to designate choice of law in general and couldn't choose to have choice of law provision by provision. Maybe that would be deemed to be unconscionable under some other state's law, but that would seem to be one limitation. And then Jean had another point, which Jean, maybe you want to explain sort of what your research was and why that might undermine the turn to states.
Well, I mean, my research was super long ago. Back when we were first looking at Terminix, I did look at what states were doing and to think about the impact of the preemption rules. And what I found back then, which was in the 1990s, if you can believe it. I mean, there were some states, including, I think it was Arkansas, or wherever it was that Terminix came out of, that had some very specific language that would prohibit arbitration, use of arbitration in certain contexts, like real estate transactions or whatever. and other states were, much more amenable to arbitration, didn't have those weird exceptions, or I would say appropriate exceptions. But this was really just an answer to your musings, Myriam, where you were wondering, what would happen if there was no preemption? What would states do? And I'm not super optimistic that most states would prohibit arbitration in many contexts. I do think there'd probably be a few, and like California and New York that might, and a lot that wouldn't.
Yeah, I think you might be right. I think you might be right. And you're certainly right about being being subject to lobbyists. All the chamber would have to do was sort of go in there with the campaign and we'd be done. And I don't even know if it'd be better to fight the fight in 50 different state capitals than to try to fight the fight in DC. I will just say that getting the FAIR Act through feels really, really difficult, probably impossible right now. I think we will have a hearing in Senate Judiciary in this spring at some point, so watch out for that. But it's a symbolic hearing. There's no way there's no way that there's not legislation even pending. There's no drafting going on alongside that hearing. It's really just to keep the issue alive. But the issue's been alive and it hasn't gotten out of committee for decades now, right? So I don't know which is better. And I think Jean makes a really good point. We would end up with a patchwork, right? Where it would be great to be an employee and a consumer in some states and terrible to be in other states. But look, many of you are in California. That's already true for you. It's much better to be an employee and a consumer in California today than it is in any other state. And that would just be all the more true if as Hero suggests, the FAA is gone, or if companies take these provisions out of arbitration, right, and just have standalone clauses.
One analogy that I think about is what's gone on among the 50 states with respect to online gambling, which is a different phenomenon, but arguably there's some synergies where it's the companies love it and it's not very good for consumers. And I remember hearing a really terrific podcast about just the techniques that companies were using to woo the legislators in various states with steak dinners and everything else. And it just wasn't very hard for them to get legislation to their liking in many states, because lots of states like Nevada have these legislatures that are, part-time legislatures. They're not even professionals. They're, just easily wooed with not a lot of money and a few steak dinners.
Yeah, it's very, very true. In my efforts to get PAGA legislation enacted, I've really come face to face with this because I've just seen legislators. They're almost all part-time legislators. I don't know if the students are aware of that. Most states, it's really, I don't think most states have full-time legislators. And some states even have legislators, it is true of Texas, that only meet once every few years, right? So it's very hard to get anything through a state legislature. And so if you're kind of a one-shotter, you've got an issue and you're just trying to get in front of a legislator, a group of legislators on one issue, if you don't have sort of see-through where you can kind of keep going on this issue for years and years, and as Jean says, woo them with some swag or other benefits, they're just not really going to give you the time of day. So it's hard. Data doesn't work. I think swag works a lot better.
So you're probably right about individual state legislatures, but the same can be said for Congress, right? Arbitration Fairness Acts from 10, 15 years ago. Every new Congress, a new Fairness Act was proposed, and it always languished in committee.
Yep.
So these kinds of reforms in Congress have comparatively done very poorly, whereas the states have been on the vanguard in terms of pro-consumer, pro-employment. At least, not all states uniformly, but many states like California, for example, had declared class action bans in arbitration and in litigation unconscionable.
Yeah.
So really the question is, do we put all our eggs in one basket? Do we kind of retain this kind of FAA preemption regime? So it all kind of comes down to what the climate is in Congress, what the Supreme Court wants to do, or do we recognize that states have a co-equal ability to regulate in this area and kind of allow them to do that with more freedom from the federal government? And I guess there's pros and cons I see with both options.
Yeah, no, I think that's absolutely right. And I don't know that we have a choice one way or the other, but it is true that that it seems difficult to get anything through Congress. And I used to have a lot more faith in, sort of just executive agencies and rule promulgation, because of course, the CFPB promulgated a rule that would have barred mandatory arbitration clauses in consumer financial contracts, only to have that rule subject to the Congressional Review Act once Trump became president. And so there was a moment when it looked like maybe agencies could promulgate rules that would do some of this work. But now none of us even knows if, agencies are going to survive this Supreme Court term. So it's hard to know, where to put your belief, given, yes, I know it might be happening again, Eitan. Right. So Eitan just put something in the chat. If you want to click on it, it's about the CFPB. Yeah, I was part of this a little bit, trying to get this in front of them. We'll see what happens. I'm much more down on the CFPB. I love what the CFPB is doing, but on this issue, they seem really gun shy about an ARB rule, because nobody's ever been able to promulgate a rule after getting CRA'd, right? It's never happened before, and it's not clear that this agency has a whole lot of chutzpah when it comes to being the first mover.
Well, Myriam, I have one theoretical question, or maybe it's a wider ranging question. It seems to me one of the interesting things about your article is to note the way that the Supreme Court and some of the conservative members of the Supreme Court, based on some of their canons of construction, have moved in ways that are actually helpful to consumers and to employees. And that's where you see some hope for Circuit City being overruled. And it's also interesting to me to see that in a completely different area, somehow after years and years of failed attempts to get employment protection for people based on sexual orientation or gender identity, somehow Justice Kavanaugh comes up with a decision extending that, doing through plain language interpretations, something that Congress and the ACLU and many other groups have not done. So I'm wondering if you have any thoughts about whether what's happening partly in these different areas is that it's a sincere commitment to certain canons of construction that therefore, or jurisprudence that therefore sometimes will have liberal results and sometimes conservative results, or if it's a kind of tokenism strategy where the results are still generally the conservative approach to jurisprudence, including limiting agency power, for example, is generally conservative, but in order to have this veneer of being nonpartisan or not being results driven, every now and then there will be some little token that's thrown in, which could be similar to what happened with changes only on sexual harassment, but not on other forms of discrimination.
So let me answer this way. What I believe in my heart might not be as important as how I hope we approach the court. And so Jen Bennett and I are actually trying to find a case vehicle that would be a good challenge to Circuit City, which means you sort of have to start at the lower courts level and sort of find the case. We are approaching this, we are assuming good faith among the justices, which is hard for me because I don't think I actually do believe that. But I think one has to, if you're going to take this seriously, then we have to assume that they mean what they say, and we're going to hold them to what they've said, and try really hard to get them to apply what they've said in other contexts to a case seeking FAA1 exclusion that straightforwardly challenges Circuit City. Who knows if we'll win? And if we don't, I'll be back here telling you the game is rigged. They never meant it. It was only tokenism when it was easy and cheap, when it actually meant something, when it could possibly change a lot of people's access to justice. They shut the door. They found a squirrely way out. and that could happen. But I think if you go into any of these projects thinking that it's going to happen, I'm not sure it's worth doing it at all, right? Because if the whole thing is rigged, then I'm not even sure why I'm teaching law school. So I'm going to go into this, with good faith myself. I really believe that Circuit City was wrongly decided, and I'm going to do everything I can to convince the court that it should stand by, that certain members of the court should stand by what they've written in prior decisions on canons of construction like adjustum.
Well, excellent. That's probably close to the last word. I really commend you for your commitment to this and for following through and making it so readable as well. And I think that as I look at the paper and like reflect on it, what's terrific is that it's kind of like a great investment strategy. It's not invested solely in hoping that plaintiffs' lawyers will get it right, or hoping that Congress will get it right, or hoping that the states will get it right, or hoping that the court will somehow get it right. That you've laid out in the paper, even more than in the presentation today and the Q&A, these many different avenues, not knowing which of them will bear fruit at one point, but laying out this plausible case. And that's, to me, why the unraveling metaphor is so wonderful. It's, if you imagine there's this tapestry, it's pulling on different things and not knowing when you're going to get the critical mass that the tapestry falls apart. So thank you very, very much for joining us. And
thank you, Clark, for hosting me. And thank you to all of you for such an engaged discussion. I really appreciate it. Really, really do. Thank you so much.
Thanks. Take care.
Take care.